made by Congress, all right? And when I got into Title 15, 1601 through 1693, I was studying equity heavily. So I could see the equity within it, okay? And I allowed it to cloud my judgment. And here's what I mean by that. The inclusion of one thing is the exclusion of all others. And what I overlooked, because I was so excited, they always talk about real estate. They always talk about loans. But as you read 1601 through 1693, they start using words like dwelling. They start using words like, what else they got out there? Consumer credit, okay? And I kept reading these declarations and purposes that say from Congress that it's to be liberally construed in favor of the consumer. What I didn't realize is that Title 15, 1601 through 1693 was created by the Bank of International Settlement. They wrote it up. They drafted it. The Bank of International Settlement and the presumably IMF and Federal Reserve drafted that. And it's written intentionally to deceive. It looks like it's there to give you a form or a line of protection. And it wasn't until I started reading Carl's material that I realized that I had made a egregious mistake. And the problem with it is I have hundreds of people, possibly thousands, that listen to me worldwide. And immediately as I started to read Carl's post, my heart just got real heavy. There's a huge burden that falls upon me because so many people like yourselves, come to me for quality information. And the other thing about it is not having the proper information, utilizing the information that was bestowed upon you earlier could cause harm, damage, loss, and a hardship. And that weighs real heavy on my heart. So I'm kicking ass at an expedited rate, trying to digest all of this expeditiously so I can get it back to you guys and help you guys understand and comprehend that Title 15, the FTC, the CFPB, the CRA, those are not going to be your best option, okay? And as I was reading Carl's post, I was supposed to go to bed that night. It didn't end up happening, okay? I started trying to prove what he was saying to be incorrect or an improper assessment because I've gotten very fluent with Title 15. I mean, I'm so smooth with it, it sounds like a lullaby, all right? But as I was reading his post and I'm double checking his work and I'm going through it and I'm verifying what he's saying is true, and the more and more that I went through verifying his post, I realized that all of you guys are in harm's way using Title 15. I could never figure out how we could prevail one day in the same county. We could prevail in a case using Title 15, and the very next day we would turn around and lose a case utilizing Title 15, and I just couldn't figure it out. And as I was reading Carl's work, I realized what was going on. It's one of those things where to give the illusion of justice, to give the illusion of fairness, they let a few slip through the cracks, and of course they run around and they tell hundreds of people, and it allows those other people to come in with the same futile arguments, and they fleece every last one of them. So they'll let a few of you through, and then they know that you're going to run around on social media and tell everybody what you did and what you accomplished, and you're going to share your paperwork, and that will invite hundreds of more people to come with the same shit, and they'll flush them all right down the toilet. They'll run them right through the chute, they'll fleece them, they'll shear them, and force them out the back door, okay? So reading Carl's work, I realized really quickly that this is a very serious issue. And what he was able to convey and point out to me, and of course we haven't spoken, I'm just reading his post. Again, there's no substitution for reading. It was so clairvoyant after I read his post. It's a consumer credit transaction, okay? And then they say that it's a commercial loan, all in the same paragraph. And in doing so, the inclusion of one thing is the exclusion of all others. So let me put it to you like this. When they say a person is a trust corporation, a joint business venture, an LLC, a corporation, okay? That excludes man. The person is, from that point on, is a thing, all right? And it's a trust, it's a business, it's a co-op, it's all these different things, but one thing it is not is a man, and that's where I screwed up. I was looking at it through the eyes of equity, thinking that the consumer was the private side of the transaction, and as I started looking at it, the very word transaction in and of itself is commercial in its nature. And so when he pointed that out in one of these posts, I was like, son of a bitch. And my heart just sank because you guys got to have this information. You got to have it. This is the difference between succeeding and possibly losing your house and having your kids on the side of the road. And I don't want to be responsible for that. So now that you guys know the backstory, you understand what I'm talking about. I'm not saying that you can't prevail with Title 15. I'm saying it's a coin toss, ladies and gentlemen. I'm saying I got friends. I myself have prevailed with Title 15. I'm telling you right now, it's Russian roulette with Title 15 because it's all commerce, and the consumer actually owes the debt. And what you're doing when you go in there and dispute the validity and all these things, the denial of one thing affirms 1,000 others, okay? So to deny one thing is to affirm 1,000 others. Or to deny one thing is to affirm its equal and opposite, okay? And in doing that, what you're actually doing is called confessed judgment. All right, and it's an egregious mistake. So, do I regret learning it all? Do I regret doing all that? No. There's some great stuff within there, but I wanted to point out that I got sucked into it by looking at the intent of Congress, believing that they were actually doing something for the people, and they weren't. The reason that Title 15 being drafted up by the Bank of International Settlement is because the Congress decided that they were going to back the bonds on the back side. All right, and so it's a money making deal, banking and wagering that the people of the nation aren't intelligent enough to figure it out. And let me tell you, when I say they've been making some coin, they've been making some coin. All right. So let's delve into this. I've got it broken down into sections. I'm gonna eventually put it into a series. I've already got the document started, but I'm not ready to share that with you yet. We will visit some of it this evening, but we're gonna bust down probably the better 30 of these emails that he emailed myself from his own posts, and they're very, very important. All right. So, putting Congress between you and them. Options. Congress stated in Public Law 89-485, that's Title 12, United States Code 371. Write it down. Public Law 89-485, that's Title 12, United States Code 371. So do you guys see how the public law correlates with the statute? This is important. The authority to make real estate loans. All right, this is where you're finding the public law in harmony with the statute at Title 12. So it's Public Law 89-485, and I'm telling you, this is very important. Write it down. And Title 12, United States Code 371. And the reason this is so important is when I finally divulged to you how these banking associations are working. They're not banks, ladies and gentlemen. All right? So Public Law 89-485, that is Title 12, United States Code 371, the authority to make real estate loans. real estate loans. Okay, keep that in mind. That's where they're getting the authority to create real estate loans. Is merely a codification of Section 23A of the Federal Reserve Act. Write that down. The Public Law 89485, which is Title 12, United States Code 371, is merely a codification of Section 23, Michael Jordan's number, 23, capital A, of the Federal Reserve Act. The Federal Reserve Act was enacted in 1913. It was concocted in 1910 on Jekyll Island. In 1913, the scoundrel Woodrow Wilson signed it in the wee hours of the evening on Christmas. They always do their nefarious activity in the wee hours of the morning, typically on a holiday of some sort. Anyway, that's when it was done, all right? And so we're talking about the codification of Section 23A of the Federal Reserve Act. Transactions with affiliates, okay? Affiliates. Affiliate is not a bank, all right? They are banking associations, all right? And they have affiliates, partners, joint business ventures is what they're into, all right? Secured by a collateral deposit of 100% deposit in cash. Now, when we're looking at the statute, the court has to literally interpret the statute as it is written. They're not allowed to deviate from it. If it's vague and ambiguous, there could be some discussion about it. But in this particular instant, it is very clear what is being said. Public Law 89485, which is Title 12, United States Code 371, which is what affirms that they have the ability to create real estate loans. All right? These banking associations, they're not banks, is merely a codification of Section 23A of the Federal Reserve Act. Transactions with affiliates secured by collateral deposit. All right? Now, that collateral deposit is actually called collateral cash deposit account or a cash collateral deposit account. And I've even heard bankers say that that's asset matching credit liability deposit account. But the actual term for it that you will find is called a collateral deposit account. Write it down. Collateral deposit account. This is very important. This is the bank's liability side of the ledger owing to you. And you need to be able to properly identify it because Congress is giving you your remedy here. Collateral deposit account is the account that they are holding for your offset or set off. All right. And I just went through a 299-page book before I got on here that is all the renderings from Supreme Courts from 1998 to 1993, in fact. All right. And we'll get into that a little bit later, too. So collateral deposit account, sometimes it's identified as a collateral cash deposit account or a cash collateral deposit account. And the banking lingo that I've heard just talking to bankers is asset matching credit liability deposit account. All right. Now that in the books is not there. This is slang. The asset matching credit liability deposit account, that's slang. All right. But there are some other ways you'll see it. The collateral deposit account is what's written in black and white. And then, of course, we see it sometimes articulated on paper as collateral cash deposit account or cash collateral deposit account. What the Congress and the legislators are telling you is that these banking associations do have the ability to create real estate loans, all right? And they're telling you that in Section 23 of the Federal Reserve Act, transaction with affiliates. So the banking associations are able to give real estate loans to affiliates, but there's a contingency It has to be secured by the collateral deposit account. In other words, your over-the-counter security, your promissory note. Let's say it has an actual face value of $100,000. They have to have a collateral deposit account with $100,000 of actual cash value. All right? There is no deviation from this statute, ladies and gentlemen. There's no deviation from the Federal Reserve Act. Okay? And they have to have it in physical form. But they don't. So what are they doing? What are they doing? Ladies and gentlemen, what they're doing is they're creating bookkeeping entries. They're just entering it into bookkeeping entries. So it's just, let's say it's a $100,000 note, and then they turn around and go into the bookkeeping entries and write $100,000 on their liability side of the ledger. Okay, which is the credit liability due and owing to you called the payables or account payable. All right? Keep following me, though, because this gets so fucking good. I can't believe this guy just shared this out there on Facebook. And if you're not following him, you should be. Carl Killicott. All right? In this instant matter, a real estate loan. Now, understand, real estate loan is a commercial term. All right? Everything we're talking about right now is commercial. But it gets better. With an American citizen, okay? Would trigger a fine of $1 million and 30 years in prison under Title 18, 1005, pursuant to Title 12, United States Code 503. Any filed litigation as to collection would be subject to a set-off of the mandatory cash collateral deposit account. Ladies and gentlemen, when they are foreclosing on you, they are violating the law to such a magnitude that they can face $1 million and 30 years in prison if you know what you're doing under Title 18 USC 1005, pursuant to Title 12 United States Code 503. This right here, like as I was reading this and busting this stuff down and going and double and checking his work, I'm telling you, I got goosebumps. And at the same time, my heart went out for you guys going, I gotta get this guy's information to you guys in a comprehensive manner that you comprehend what I'm actually talking about. Because Title 15 is a death trap. It's a 50-50 coin toss. It's Russian roulette. So Congress stated that Public Law 89-485, that Title 12, United States Code 371, that these banking organizations can make real estate loans, okay, to affiliates, which is codified in Section 23A of the Federal Reserve Act, which was enacted in 1913, and to my knowledge has only been amended once, and that was in 1933. Transactions with affiliates secured by collateral deposit cash accounts, wherein they have to actually have the actual cash value, but they don't. And this is what's important here, because before they can extend the loan, the regulation right here, this statute that the Federal Reserve Act number 23A stipulates and states specifically that they have to have the collateral cash account with the cash on deck to complete the transaction. They never had it, ladies and gentlemen. They never had it. All right? In this instant matter, a real estate loan with an American citizen would trigger a $1 million $1 million and 30 years in prison under Title 18, United States Code 1005, pursuant to Title 12, United States Code 503. The kicker here is it's not because they don't actually have the cash on hand to extend the loan that they would be facing 30 years in prison or a $1 million fine. Stick with me. All right, I want you to understand this very thoroughly. Any filed litigation as to the collection would be subject to a set-off of mandatory cash collateral deposit account. You have the right to set off or offset, not discharge. Quit using discharge, okay? Discharge is where the offspring shall pay for the sins of the father, because we're just kicking the can down the road. You want a set off or an offset. And what are we going to use? What account are we going to use to set off or offset the alleged debt due and owing? We're going to use the collateral cash deposit account, ladies and gentlemen. Because that collateral cash deposit account is the credit liability due and owing to us that they haven't paid us for. And so we're going to use that collateral cash deposit account against the loan account. And we're going to zero balance those books. Public Law 89-485. Public Law 89-485 of July 1st, 1966. Now, there's some beautiful things that happened in 1966. If you've been following me for any amount of time, you'll understand very quickly that the supplemental rules, the special supplemental rules for maritime admiralty, were adopted in 1966. And if you go and read the special maritime admiralty rules that they supplemented, okay, supplement, another word for supplement is substitution. Now, when you actually read it, they grabbed and gleaned something from the exclusive jurisdiction of equity. See, the public likes to go into equity and take from equity. The public side is always very zealous of the private side. And what they took from the equitable side on the private side is there's a principle that is stated in equity, that when there's a conflict of variance between the rules of law and the rules of equity, equity will prevail, okay? And this is what they did in 1966 on the public side. When there's a conflict between the rules, codes, and regulations, okay, then maritime admiralty will prevail. And that's where they implemented, substituted the special admiralty maritime rules, supplemental rules, okay? And they've been here since 1966. So this is Public Law 89485 of July 1st, 1966. I'm not saying that that necessarily has anything to do with the Maritime Admiralty Special Supplemental Rules, but we should be very cognizant of it because, ladies and gentlemen, Maritime Admiralty deals with things in rem. Okay, deals with writ of replevin, garnishment, writ of levy, foreclosures, all that stuff deals with vessels in dry dock. Okay, so understanding that, this may make this a little bit easier. Public Law 89485, July 1st, 1966. We're going to be looking at Section 6, H as in Henry, the application of this act, and of Section 23A of the Federal Reserve Act, Title 12, United States Code 371, as amended, shall not be affected. It's very important because, again, when you go into a court, we are going to scrutinize this and we are going to look at this as it is written. We're supposed to liberally construe it as it's written in its form and not take it out of context. Okay? We don't get to juke and jive from this, and it's important. You don't want to leave this poignant point. You want to stay right on point. That's why I'm stressing it so hard. The application of the Act and of Section 23A of the Federal Reserve Act, Title 12, United States Code 371, as amended, shall not be affected by the fact that a transaction, which is commercial, takes place wholly or partially outside the United States, or that a company is organized or operates outside the United States. Ladies and gentlemen, what they're telling you is that the real estate loans that these financial organizations, affiliations, are able to extend are for purposes outside the United States. How many of you in the chat right now believe you have a mortgage? How many of you realize that pursuant to Title 18 United States Code 1005 and Title 12 United States Code 503, they could be looking at 30 years in prison and $1 million for sending you statements in the mail, because they're also violating Title 18, 1341, 1342, 1343. They're violating RICO, misappropriation of funds, fraud in the inducement, fraud in the factum, concealment, failure to disclose material facts, misrepresentation of material facts, extortion. I mean, I can go on and on and on and on. I don't want to bore you to death. I really want you to understand this. Source of law, Title 12, United States Code, subsection 371, real estate loans. Now listen and pay attention. And I'm reading this stuff even slower than I was before because I'm so embarrassed of the mistake that I made in Title 15. I still am struggling with the fact that I missed it. I can't tell you how many times I've read Title 15. I've probably read that over 200 times. And somehow I completely overlooked it because I got in the moment, you know. Here's Congress advocating for the people. I'm so pumped. Only to find out that there's no room for emotion when it comes to law. Law is specific. Law has nothing to do with emotion, all right? Title 12, United States Code, subsection 371, real estate loans. A, authorization to make real estate loans, orders, rules, and regulations of comptroller of the currency. All right? One of the people we're going to be putting on notice, ladies and gentlemen, is the comptroller of the currency. We have to give them a courtesy, okay? Because of federal courthouse, and he's going to call the judge up and say, yeah, they know what they're doing. Let it go. Let it roll. Any national banking association may make, arrange, purchase, or sell loans. Listen, any national banking association may make, arrange, purchase, or sell loans or extensions of credit secured by liens on interest in real estate. Okay? If you're listening to what I'm telling you right now, I've been saying this for a couple years. When you put in a credit application and they say, congratulations, you've been approved. Come on down. You're the next contestant on We'll Fleece You Right. If you've ever slowed down before you signed your mortgage documents and really analyzed what they say that you are giving them an interest in your house, fixture filings, movable and immovable property. Okay? How can you give them an interest in something you don't own? I thought you was getting a loan. See, what they didn't disclose to you and they concealed is there was a secondary transaction, which is known as a service or a product they're providing, which is called a mortgage. All right? When they said, congratulations, you were approved, they hid from you your marketable title. The grantor had already signed. They have it. It's not in the same room with you with those mortgage documents, because if you started flipping through them and you saw that thing, you'd be like, oh, it's got my name on it, it's got the grantor's name on it, what the hell do I need you guys for? And you'd walk right out the fucking door. But I'm going to show you. That song that I started out with, It's Too Late to Apologize, we ain't playing. When you guys go in there and they start crying big old crocodile tears, I want you blasting that song. Because they're going to be like, we are so sorry. And you can be like, you're damn right. We know you's a bunch of sorry motherfuckers. You could apologize. Sorry is an emotion. We already know you're sorry. We know you're a sorry motherfucker. Okay? We're just here to get paid. All right? And be made whole. Again, let me read this real slow. Title 12, United States Code, subsection 371 is controlling real estate loans. Authorization to make real estate loans. It doesn't say extensions of consumer credit, right? Real estate loans, orders, rules, and regulations of the comptroller of the currency. Any national banking association may make, arrange, purchase, or sell loans or extensions of credit secured by liens on interest in real estate. So in order for them to be able to give you an alleged loan and treat you as a member bank, which is what they're doing, and I'll explain that here in a minute, they first have to have the ability to put a lien interest on something you already own. Congress says they can't give you a loan to acquire real estate. But under Article 1, Section 10, you're free, ladies and gentlemen. If you want to contract your property for a loan, you can do that. And that's what we're doing because we're not slowing down and reading this. And again, the credit really goes to Carl Killicott, that gentleman right there. Sharp as a tack. Source law, Section 23A of the Federal Reserve Act of 1913. Right? It hasn't changed. It's Section 23A. It's very important. You're going to drive this home. Relations with affiliates. Okay? Remember, the National Association, what people perceive to be a bank, which really isn't a bank, it's a financial institution or an association, all right, is authorized to extend loans to affiliates in this section under Section 23A, relation with affiliates. A, restrictions on transactions with affiliates. A member bank and its subsidiary may engage in a covered transaction with an affiliate. They're trying to convert you into the capacity of being an affiliate, all right? And they're using the member bank and its subsidiaries may engage in a covered transaction. What does it mean by covered? It means that you're going to pledge your real estate. You're going to pledge the lot block, parcel ID number, zone improvement project number, easement, address, and you're going to allow them to create a special purpose vehicle known as a trust. The SPV is a special purpose vehicle. That's what closing's all about. All right? And you're going to grant them an interest in the new colorable title, which is known as, it may be a warranty deed, joint tenancy deed, deed of trust. It could be a number of different things that they deem it, but they nevertheless are going to have an interest in it, thus being able to place an alleged lien on it. All right? C, collateral for certain transactions with affiliates. Here we go. 100% of the amount of such loan or extension of credit guarantee, acceptance, letter of credit, or credit exposure if the collateral is composed of C, a segregated earmarked deposit account with the member bank. Write down earmarked deposit account. We're going to get back to that a little bit later. All right. So far, what we've gleaned from this, and this is crucial, you guys need this information. We have a collateral deposit account that has to be backed up 100% with actual cash. But what they're doing, because the comptroller of currency and the way that the provisions are written, they're allowing them to make bookkeeping entries for the par value, the face value of your over-the-counter security promissory note. All right? That's what they're doing. Remember that this collateral deposit account is in place by statute, by public policy and public law to protect you and to give you the ability to offset or set off. Do not mention the word discharge. Okay? The statute is very clear. So, let's go on to the next one. I think you guys understand that. New York Fed will not confirm or deny that 5-count felon JP Chase is custodians of $2.4 trillion of its securities. A little more than a month after the Fed's mortgage-backed security announcement on December 31st, 2008, the New York Fed signed a contract with JP Morgan Chase to be the sole custodian of the securities. It bought under the MBS, Mortgage-Backed Securities Program. That contract with JP Morgan Chase was amended on April 1st, 2010. Remember, what happened in 2008? Crash, right? April 26, 2011, April 17, 2014, and again on January 30th, 2017. Remember they were too big to fail? Had to bail them all out? Remember that? As of this morning, the original contract and its amendments are available on the New York Fed's website. Highlights of the original contract and its amendments. Number 1, all securities borrowing has to be secured by a cash collateral deposit. All right, these are the new amendments. This is mandatory. See, they can't give you a loan without actually having the actual cash value, but they're doing it anyway because their policy provides for them to make bookkeeping entries. But policy, ladies and gentlemen, does not trump the statute that requires them to have actual cash collateral deposit for your benefit to set off or offset the debt. 2, any and all vendors have to vigorously maintain a record. That record, again, when you're first doing your transaction, that will be the call reports. You will be looking at the schedule sheet, and you'll be looking for RC, which is going to be the asset side of the ledger that is owing to you, which is actually your promissory note. Okay? And because they have your promissory note, and they're going to go ahead and make a book entry pretending to have the cash collateral deposit account full of the actual cash they're supposed to have on hand, and they don't, they're going to match your over-the-counter security with a book entry. All right? And they're going to create this cash collateral deposit account, and that's going to raise the liability and the assets of the bank, their books. How do we discover that? Ladies and gentlemen, you don't even have to take them into court. You can get the call reports. Line 13 on the RC sheet, the schedule sheet, is going to be your over-the-counter securities actual face value. Okay? And then line 7 on RC-E is going to be their credit liability that is due and owing to you, known as the accounts payable. That's the collateral cash deposit account they're talking about for set off or offset of the debt. All right? It's really elementary. It's beautifully concocted, so it was confusing at first, but as soon as I started reading what Carl was posting, I don't know what this guy's former profession was, but I can tell you right now, he is sharp, sharp, sharp. Number 3, any and all participants reserve the right to a set-off. Now, in this instance, okay, you got the bank and you got yourself, both participants. And you have the reserve, the right to set off, not discharge, set off or offset of the mandatory cash collateral deposit. Any and all participants reserve the right to set off of the mandatory cash collateral deposit for the sole purpose of settlement of an account. This is verbatim. All right? These are the words you use. Don't grow a brain. Don't get all funky. Don't start, doing the cha-cha and ad-libbing and adding shit to it. Use the words verbatim. Words have power. They have meaning. There's a reason they're structured the way they are. Don't give them a way out by growing a brain. Any and all participants reserve the right to a set-off. It's your right to set off or offset of the mandatory cash collateral deposit for the sole purpose of settlement of any account conducted through a automated clearinghouse ACH system located at an international banking facility outside of the United States. See Title 12 CFR 204. Now, we haven't gotten to the point yet that you guys are going to be like, damn. And I'm telling you right now, you guys are going to be like, oh, you're not going to be able to sleep tonight once we get there and I explain to you why what was just articulated is absolutely damning to these guys. Listen, outside the United States, Congress, the legislator, the comptroller of the currency, the Bank of International Settlement is saying these people can only extend loans outside the United States. Ladies and gentlemen, how did you get a mortgage in Kansas? How did you get a mortgage inland, domestic, not external, domestic? How did you get a real estate loan and get real estate, okay, if they're not allowed to do business internally, domestically? So saith Title 12, CFR 204. All right? They're a banking facility. They are not a bank. 4, according to Title 12, CFR 210, the New York Federal Reserve Bank doesn't actually exist. It's actually located in Puerto Rico. What else do we know is located in Puerto Rico, ladies and gentlemen? Oh, that's right, the IRS. That's where the special trust funds are at, the IRS. Number 5, any and all litigation concerning mortgage-backed securities have to be litigated in the New York Federal District Court. See Title 12, United States Code 632. How many of you have known a friend, a neighbor, a constituent, aunt and uncle, where they have been foreclosed on in the lower state courts, the lower state district courts? Now, as you're reading, you're not reading, I'm reading. As I'm reading and explaining this to you, you should become cognizantly aware that they're in the wrong venue, wrong jurisdiction. They don't have the ability to foreclose. It gets better. It gets so much better than that. But you should be consciously aware now that a mortgage-backed security and a foreclosure on a mortgage-backed security cannot happen anywhere else but the New York Federal District Court. What else is in New York? Is it not the capital of the world? It's the banking mecca. It's got the DTC. It's got the DTCC, right? Okay? Now, number 6, page 10 of the original contract and its amendments, glossary of terms, lists the authorized securities as Section 31 of Title 31, United States Code, restricted to the Second Liberty Bond Act of 1917. The Second Liberty Bond Act of 1917 loans to foreign nations. The foreign nations that they're authorized to extend those loans to is Europe, ladies and gentlemen. It's not you. Congress never authorized them to have the ability to do banking internally. They're not even supposed to take your deposits. They're not supposed to have sending you statements. They're not supposed to say that they even have a loan with you or that they extended you credit. And to boot, they're not even following Federal Reserve Act 23A and actually have the cash deposit account and the actual cash in it. They're doing bookkeeping entries. They're violating law all the way around. You can't sling a dead cat without hitting a remedy, ladies and gentlemen. Number 7, J.P. Morgan Chase, domiciled in England, is an EDGE, that's EDGE Act corporation, not permitted to conduct banking business in the United States. Any of these affiliates, any of these alleged banks, all right, which are really just branches or extensions, because their headquarters and true foreign principal is in another country, all right? And therefore, they're not allowed to be extending credit. They're not able to create loans. They're not able to create mortgage-backed securities. That's all heavily forbidden. But they're doing it, and you might be asking, how and why are they getting away with it? Well, because Article 1, Section 10, government can't impede the obligation of private contract. And although you're engaged in commerce, they consider it a private transaction. And therefore, they can't stop you from pledging your house, your boat, your building, your car as collateral security in order to secure a would-be alleged loan, which is really nothing more than a book entry on their side of the ledger. When by the very nature of the Federal Reserve Act number 23, it's supposed to actually be a collateral cash deposit. All right? I'm going to keep reiterating it because it's so important. This is so simple that I really struggled with it reading it, because I've read some shit over the last 15 years and I was just in complete disarray the way that Carl Collicott broke this down. Let's move on. Not sure if we already went over this, but the attorney for Wells Fargo informed the Supreme Court in 1989, write it down, Wells Fargo, the attorney for Wells Fargo in 1989 informed the Supreme Court, national banking associations, okay, they're associations, they're not banks. Tomorrow morning when you go to work or sometime you get out the house, I want you to go drive by all the banks, and I'll bet my testicles on it, none of them just say bank. All right, they'll say, they'll be altered heavily. I remember when I was a kid, they used to say bank. They don't say bank anymore. All right? National Banking Association, bank holding companies, or mortgage loan servicers. Mortgage loan servicers, bank holding companies, and national banking associations are not permitted to use state courts to litigate any perceived enforceable contract. Ladies and gentlemen, if they are foreclosing on you in a state court, you got them dead to rights. And if the judge rules in their favor, his ass is going to the hoosgow. He is in direct violation of Congress and the intent of Congress. And I'm telling you, they do know this, but you're going to have to point it out to them, and you're going to have to show them the enactment clause, the public law, the public policy, and the Federal Reserve Act to prove it to them that this is way outside your jurisdiction, Scooter. All right? Again, let's just go over it. National bank associations, bank holding companies, and mortgage loan servicers. Who's the one ringing your phone? Who's the one sending you mail? Mortgage loan servicers, right? They're affiliates of a foreign entity, all right, that are not authorized to make transactions in the United States. They're supposed to be doing all their transaction outside the United States, so saith the statute, verbatim. Are not permitted to use state courts to litigate any perceived enforceable contract. If they're bringing you into a state court, ladies and gentlemen, they screwed up. You got a cause of action immediately. 2, as of 1941, 12 United States Code 632 requires the attendance of the Federal Secretary of State. So when they are foreclosing on you, the Federal Secretary of State is supposed to be in attendance. Okay? 3, the only property listed for litigation has to be personal property, stock, bonds, owned by a foreign country agent. In other words, ladies and gentlemen, the only thing they can foreclose on is stocks and bonds owned by a agent of a foreign country or a foreign country. They cannot foreclose on you guys. How they're foreclosing, you may be asking. Well, it is written that if you don't make the issue, you waive the issue. All right? If you're in the state venue, you would be bringing a claim against the mortgage servicer or the attorneys who's attempting to foreclose because they're engaged in a simulated legal process using sham pleadings. They're not sworn to or verifiable under the pains and penalties of perjury, and they are clearly violating the intent of Congress, the public law, the public policy, and the statute, along with, to boot, the Federal Reserve Act 23A. And the comptroller of the currency is responsible for keeping all these banks, affiliates, member banks, non-member banks, and branches accountable. Okay? So this is why the comptroller of the currency is going to become your new best friend. Because the Supreme Court has clearly ruled when you give them notice of the law, that is more than sufficient and grounds for suit if they persist on. Title 12 United States Code 632 does not list any type of foreclosure or private law firms. Ladies and gentlemen, you got a private law firm trying to foreclose on you. But Title 26 United States Code 632 does not permit for foreclosure or for private law firms to engage in foreclosure. Ladies and gentlemen, if on the paperwork the attorney has state law on the paperwork, right from the word go, they are fatally flawed. And you have a right of action, a cause of action against them, because no state law can be utilized because this is federal. It's international. It's governed by the law of nations, the Bank of International Settlement. It's governed by the Congress. And these transactions are supposed to be happening outside the United States. And a foreclosure, as we mentioned earlier, has to happen where? In New York. Source: Wells Fargo complaint invoked the court's jurisdiction based on a provision of federal banking law provided that all suits of a civil nature at common law or in equity. Remember, they blended common law and equity under the Judicature Act, right? To which any corporation organized under the laws of the United States shall be a party arising out of a transaction. A transaction, again, is commercial. It's commercial in its nature, involving international or foreign banking, shall be deemed to arise under the laws of the United States, and the District Court of the United States shall have original jurisdiction of all suits. Wells Fargo complaint invoked the court's jurisdiction based on a provision of federal banking law, providing that all suits of a civil nature at common law or in equity to which any corporation organized under the laws of the United States shall be a party arising out of a transaction involving international or foreign banking. Did you realize, were you availed of the fact that you were engaged in an international and foreign transaction? Did anybody apprise you of that information? Were you availed of that? Did they conceal or misrepresent material fact? Shall be deemed to arise under the laws of the United States. Well, we already know under the laws of the United States, they're not even allowed to do business internally, domestically. And the District Court of the United States shall have original jurisdiction. So what are you trying to do, foreclose on me in a low rank county court or district court in the county when the state doesn't have jurisdiction? It's federal. Of all such suits, that's Title 12, United States Code 632. Title 12, United States Code 632 is what is going to grant you the ability to shut down the foreclosure at the state level immediately. Okay? And we'll go a little deeper in here because you got to understand why the judge is going to capitulate, because he does not want to go to Guantanamo and he does not want to lose his multi-million-dollar retirement. It is not worth it to him. There can be no doubt that this court may resolve the case on non-federal grounds. In other words, if you waive your right, if they're using the state statutes, codes, city ordinances, rules, and regulations, and you don't make issue with it, ladies and gentlemen, that's a problem. Make the issue. Title 12, United States Code 632. This is a federal matter. The state has no business with this. Okay? And it is significant that Congress has determined that disputes arising out of a transaction involving international or foreign banking are sufficiently important and have a sufficient nexus to federal interest to be deemed federal questions for purposes of federal court jurisdiction. See Title 12, United States Code 632. This is Citibank NA, which stands for National Association. Anytime you see, just going to put it out there, anytime you see, let's say you did a transaction with Wells Fargo. What happens in 30 days? They send you a notice and they say, hey, we transferred that account over to Wells Fargo NA. How many of you know what NA actually stands for? NA stands for National Association. National Association means they're principals in a foreign country, guys. They're a branch. They're a branch. They're not the actual bank. The branch doesn't have the actual cash to back up the collateral cash deposit, ladies and gentlemen. They're screwed from the word jump. Because Congress is saying you can't even get a loan unless they had the actual cash on hand. And they never do. Citibank NA petitioner versus Wells Fargo Asia Limited. I said Fraudo, just fucking around. It's Wells Fargo. See, that was 4. Man, this shit is so good. Consequences, right? Let me turn off this heater. I'm getting all worked up in here. It ain't even that damn warm out here in the shop. But I'll tell you what, I'm getting worked up over this because this is so beautiful. And we all owe Carl a great bit of gratitude. And if you swing by his Facebook wall, make sure to drop him a like and tell him thank you. Tell him thank you. This man is saving people clean across this country. And he, whether he's aware of it or not, swing by and say hello and say thanks. Enforcement. Where are we going to get our enforcement? Okay, we've already determined that state courts can't do fuck all. So we're good there, right? And we've also established that if any factor is attempting to foreclose, a third-party debt collector is attempting to foreclose, they're using a simulated legal process with sham pleadings, which means under the False Claims Act, you got them dead to rights. They're fucked. The judge is not going to jump on this hand grenade. I'm telling you this right now. If you slow down, take the time to learn this, and understand exactly what Carl has blessed us with, you guys are going to be grinning from ear to ear. You could change your whole community with this. New roads, new substructures, new sewer lines. I mean, this isn't about houses and cars, boats and hoes, ladies and gentlemen. I'm talking you could put new nice parks, in-ground greenhouses that produce food year-round, reverse osmosis systems in people's houses so you can reduce bacteria and stuff and not have an underground sewer line and things of that nature that are detrimental and harbor bacteria and all that great shit, right? Title 18 United States Code subsection 1005 is your enforcement. Bank entries, reports, and transactions, sections 2 imposes a $1 million or imprisoned not more than 30 years or both on whoever without such authority makes a mortgage, judgment, or decree. Additionally, it would include a judge that puts forth a judgment or decree. Ladies and gentlemen, if that lower state court judge does not take heed in what you are conveying, and you have produced the law to him and told him you are without the authority, you do not have jurisdiction, this is a federal issue and you are way out of your league, Scooter. Way out of your league. And pursuant to Title 18, USC 1005, bank entries, reports, and transactions, Sections 2 imposes a $1 million or imprison not more than 30 years. 30 years. And I'm going to tell you right now, if a judge bulldogs through this and says, so what, sue me? I'm telling you right now, as soon as you get a hold of the comptroller of the currency, he's going to be sorry and sad. Very, very sad. Okay? Especially if upon investigation they find out there's a bunch of state laws thrown in there to try and aid and abet the foreclosure, which is RICO, and they do a little more deductive reasoning and look at the paperwork and realize that the pleadings aren't properly sworn to under the pains and penalties of perjury. Okay? They're going to be in some real hot water. And the bonus for you is there isn't a judge throughout the United States that doesn't retire a multimillionaire. So he's definitely got the money to pay you. That's the bonus. You don't even have to necessarily go after his bond. He just hit his own fucking bank account for his ignorance. And he can also go to Guantanamo for 30 years. That's a hell of a consolation prize for being stupid. Or both on whoever without such authority makes a mortgage, ladies and gentlemen. Did the bank make a mortgage? That's $1 million in your pocket. Do you have a statement that proves that? Do you have the RC call reports, scheduling sheet, line 13 showing your over-the-counter security as an asset to the bank, increasing the bank's liability? Can you get a hold of the RC-E as an elephant line number 7 and show that they made a book entry to create the collateral cash deposit that is mandated by the statute, mandated by public law, public policy, and also mandated by the Congress that they have to have, so you can do a offset and an offset or a set off against the account. This is so simple. 2 paragraphs. I could probably break it down to 5 fucking sentences if I really want to get tricky dicky about it. I could probably break it down in 5 sentences. Source: whoever without such authority makes, draws, issues, puts forth, or assigns any certificate of a deposit. What's another word for certificate of deposit? It's really not a word. They call it a CD. Certificate of deposit is otherwise identified as CD. Have you ever heard of CDs before? Typically, Depository Trust Company deals with CD, certificate of deposit. That's also what your birth certificate is. It's a certificate of deposit or a certificate of indebtedness. Draft, order, bill of exchange, acceptance, note, including promissory note. Note, including promissory note. Note, including promissory note. Note, including promissory note.
Damn. Might be the end of it.
So, are all mortgages lawful? That is no. The ability out and pursuant to the public law and pursuant to the United States Code. Okay, so they can make, it's all outside of the United States. When did you get put on a boat, taken out past the Bermuda Triangle, and they said, here, sign this. While you're out here, let's do. You guys get a boat ride? I sure the hell didn't get a boat ride. I want a boat ride. All right? I'd like to do some fishing. Question. Would a judge's judgment or decree enforcing a mortgage or mortgage foreclosure always be lawful? Right? And the answer is yes. Excuse me. I asked these questions backwards. Question. So are all mortgages unlawful? The answer is no. Question. Would a judge's judgment or decree enforcing a mortgage or mortgage foreclosure always be unlawful? The answer is yes. Okay? So, they're affirming, and this is Carl, by the way. Carl's affirming that not all mortgages are necessarily unlawful because we have to take into consideration what the statute says, and the statute says that they can make loans outside of the United States to other countries, okay? But the foreclosure aspect, domestically, internally, on a mortgage or a foreclosure, is absolutely unlawful, all right? And it's illegal. Anyone puzzled yet? Like, as I was reading this, I realized that I was so far off base on Title 15, and I was scrambling back into Title 15 to look where I went wrong, and it was staring me right in the face. And I was like, gosh, you can't be right. I kept going back and looking at Congress declaration and finding of facts and purpose and intent, and I'm like, he just can't be right. I gotta prove this guy wrong. He's made a wrong assessment here. This can't be correct. 3 3 hours of trying to prove him wrong before I had to put my ego to the side and realize I fucked up. I drew an inference from an inference, which is exactly what I tell people not to do because it puts you way out in left field, and that's dangerous. Part of the reason that I was able to hang on to that inference from an inference for so long is because I've probably been involved in 30 different foreclosures, and we've won over the better of half of them. And you win some, and then all of a sudden you lose. And I just could never understand the flip-flop. It just didn't make no stinking sense. Prevail in one and flop in the other, and they were literally 24 hours apart. And I'm going, how is this possible? They give the illusion, right? They give the illusion so they can maintain the scheme. Because if they just went and wiped everybody out, which they could. If you were just using the FDCPA and they really didn't want to show you any grace or give the illusion that it's fair, they'd just wipe everybody out. And that's what's so important about what Carl's showing here, because this stops all that shit. This is where you end up being able to utilize what is called the right in recoupment. Write it down. Right in recoupment. You're not gonna be suing. It's a right in recoupment. All right? It's all your rights, titles, interests, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, child securities, trust residuals, trust residue, rents, profits, proceeds, futures, and annuities. You're entitled to all of it, and there's not a damn thing they can do about it except for say, we'll have that here by 8 a.m. Thank you. No bullshit. With what Carl is showing everybody, they are going to capitulate. They might even show up at your place in a limo. Well, the answer is actually found in Title 12, United States Code 503. Title 12, United States Code 503. 1. A mortgage loan of credit is permitted provided the borrower is a member bank officer. Willis, when the hell did you get hired at the bank? How you getting a loan if you ain't a member bank officer? You know, like an executor, a director, or an officer of the bank getting a paycheck week in and week out. How much they been paying you? You just been working for free because you just like that. Look, Title 12, United States Code, subsection 503 says that the only way that you can get a mortgage loan of credit internally, domestically, is if you are a member of the member bank and you are an officer, executor, or administrator of the member bank. If you don't meet those qualifications, guess what? It's an impossibility for you to have a mortgage. What they're doing is they're getting you guys to confess, and it's called confessed judgment. You might say, well, I owe, but it isn't that much. I made my payments. That right there's confessed judgment. And they're rolling your asses. What they're actually doing in state courts is they're wagering. The state judiciary, which really isn't a judiciary, is robbing the American people fucking blind due to their ignorance. And in 2025, we will not have that anymore. That's coming to an end real quick. Now I understand why they're trying to flip the financial system so fast, because you, ladies and gentlemen, are becoming extraordinarily knowledgeable at an expedited rate, and it is scaring the shit out of them. 2, there could never be any enforcing a mortgage or a mortgage foreclosure for 2 reasons. 1, member bank officer director are not permitted to conduct business in the several states. Remember, when I said internal, domestic, they're talking about the several states, baby. The union of states, the several states. Okay? They can't do business in the several states. You're in the several states. You got to rebut and rebuke the presumption and assumption, all right? And let them know, hey, we're in the several states. How did you authorize a loan when the comptroller of the currency himself is going to testify that pursuant to their own policy, you can't extend credit. You can't create mortgage-backed securities. You can't extend cash. Okay? internally, domestically, in the several states. So saith the Congress, pursuant to Title 12, United States Code 615. That's Title 12, United States Code 615. Stay with me. Another code here. Title 12, Code of Federal Regulations, CFR 211. Title 12, CFR 211. Here's another one for you. Pursuant to Title 12, CFR 28, that's 12 CFR 28 and 12 CFR 347.105. All right? So there's your codes. All right? This is your, you already have the Gatling machine, and these are all your bullets, okay? These are your rounds of ammunition they just can't get through. This is your armor of God, if you will, the breastplates of righteousness. Public Law 89485, remember we went over Public Law 89485 and Section 3. And then we have Title 12, United States Code 1843. So Public Law 89485, Section 3. It's important to remember that section. And then Title 12, United States Code 1843. How we know the judge ain't going to just go piss off and foreclose on us? Title 18, 1005, ladies and gentlemen. Title 18, 1005, and Public Law 89485, Section 3. All right? 2, member bank officers, directors, transactions have to be secured by a collateral deposit account, 100% backed by cash. I've already told you, they never do that. Because where is the actual cash at? It's over there at the Bank of International Settlement. It's over there in Europe or in Germany, depending on where the headquarters of these different banking branches are that you're dealing with. Okay, these are just affiliates. They're foreign bank branches. It's not the actual bank. They're bank associations. All right, cited in Section 23 of the Federal Reserve Act and 1933 amendment to Section 22 of the said Act, Title 12, United States Code 375A. All right? So pursuant to Title 12, United States Code 375A, and the amendment to the Federal Reserve Act, Section 22, and Section 23, member bank officer director transactions have to be secured by a collateral cash deposit, 100% in cash. All right, what they're doing is they're making book entry. They're putting it in a book entry, and that is not following. That is not following, ladies and gentlemen, the provisions, the guidelines, and the statutes, and the public law. All right? They're saying by their private internal policy, they're just able to go ahead and create book entry. So essentially, did they loan you anything? No. Are they in breach of duty? Yes. Are they violating the law? Yes. Are they robbing you fucking blind? Yes. Do they have the ability to get away with it? Only if you're dumb enough to let them. Title 12, United States Code, subsection 503, liability of directors and officers of member banks. All right? Title 12, United States Code, subsection 503, liability of directors and officers of member banks. We cannot afford to be ignorant no longer, people. Those days they're long gone. If the director or officer of any member bank shall knowingly violate or permit any of the agents, officers, or directors of any member bank to violate any of the provisions of Section 375. Remember, we were talking about 375 earlier, right? 375A, that's the big one. And 375B, that's another big one. 375A and 375B, that's what you're going to hang your hat on. And 376 of this title or regulations of the board made under authority thereof, or any of the provisions of sections 217, 218, 219, 221, and 655. Here's another one. Title 18, 1005. That's that $1 million and 30 years in prison, right? And what are they saying? Any director, officer, agent, affiliate, right? That includes the attorneys and the law firms. Title 18, 1014, Title 18, 1906, or Title 18, 1909 of Title 18. Every director and officer participating in or assenting to such violation shall be held liable in his personal capacity and individual capacity for all damages which the member bank, its shareholders, or any other persons shall have sustained in consequence of such violation. Now, do you see where you got the power to tell them, hey, you know what? We could go to war, but it won't bode well for you. It's really not going to end well. But you know what we could do? We could take that collateral cash deposit account. We could go ahead and use that to just zero balance everything. What do you say, Scooter? Because now that I've availed you of the law, ignorance of the law doesn't excuse you anymore. Because, see, that's what they're doing. They're saying, oh, well, we just follow our internal policy. And so they abscond from having any firsthand perfected knowledge. That's why everybody's so compartmentalized. Well, Nancy didn't know. She works with internal policy. How would she know? Well, I put everybody on notice, including the comptroller of the currency. I'll let him know what bank. He's probably going to ring your phone any minute now. So what do you say? Should we just use that collateral cash deposit to offset the balance? To offset? To set off? And render and close the account? What do you think? I mean, because I don't mind going to court with you. It's a guaranteed $1 million for me. It's guaranteed. So, however you want to play it. Source, Title 12, United States Code, subsection 375A. Loans to executive officers of banks. Title 12, United States Code, subsection 375A only permits and allows them internally, domestically in the several states to issue loans to their executive officers of banks. Are you an executive officer of the bank? Where's your check? Shit, never mind. Don't even worry about using that collateral offset deposit account to settle and close the matter. I'll tell you what. I'm just going to go ahead and give you this $9 million invoice for my 8 hours of service today, since you gainfully employed me and we never discussed my wages. I mean, I see the bankers getting $50 million bonuses at Christmas. Surely I'm worth $1.9 million for the 8 hours I've been here today. How about that? Right? Which lies the truth? Which way do you want to fall on the sword? No executive officer of any member bank may become indebted to that member bank except by means of an extension of credit, which the bank is authorized to make under this section. Again, we're talking about executive officers of banks being able to get loans, but they've got to be a member of the bank, right? They got to be an employee. No executive officer of any member bank may become indebted to that member bank except by means of an extension of credit, which the bank is authorized to make under this section. 2, mortgage loans. This is going to grab you by the short and curlies. And again, I want to thank the Heavenly Father for Carl Killicott, because holy shit. 2, mortgage loans. A member bank may make a loan to any executive officer of the bank if, at the time the loan is made, A, it is secured by a first lien on a dwelling. And see, when I came across this word right here, that's when I realized that he wasn't wrong. Because see, remember, when I started busting up his work and going back and looking into it, it wasn't until I hit that word dwelling, because in Title 15, that's exactly what they use. They don't use real estate. They don't use residence. They use dwelling, principal dwelling. That's what they use. In Title 15, 1635, they use abode in Title 15, 1692. But when I saw the word dwelling right here, I realized instantly it was commercial. I was going, son of a bitch. I've been hoodwinked. I let my emotions get in the way, cloud my judgment. And now I got to come out here and correct the record so a bunch of people don't get hurt. A, it is secured by a first lien on a dwelling, which is expected after the making of the loan to be owned by the officer and used by him as his residence. Did you see anywhere in there where they could give you a loan, an extension of credit? No. I mean, maybe you are an executive officer of a member bank or a bank. Maybe you are. Maybe you are bound by this. But I'm going to venture to say that if you are not, you most certainly are not engaged in a mortgage. You most certainly are not receiving a loan. But we can settle this real quick and just tell them to use the collateral cash deposit account to set off or offset anything due and owing. This is December 23rd, 1913, Chapter 6, subsection 22G, as added June 6th, 1933. Let's go to the next one. If I'm lulling you to sleep, my humblest apologies, but this is so important because I haven't been able to sleep since I realized how bad I fucked up and how much danger I put people in. And that bothers me something fierce. And that's why I'm on here this evening, walking you guys through this. And I'm already putting a document together. It's just going to be bad to the fucking bone. This thing's going to be meaner than all get out. And it's going to be a little booklet, a little brochure. And it's all thanks to Carl Killicott. So if you swing by on Facebook, make sure to show that man some love. Because that guy, wow, what he's done for his fellow brothers and sisters is amazing. A home loan is an advance of funds loan to a member bank. Does that say individual? Person? Man? Customer? No. A home loan is an advance of funds loan to a member bank secured by a deposit or pledge of bonds from the borrowing bank. Transferring home loans into securities would be eligible securities since it pertains to member bank transactions. However, the settlement of accounts, remember, we're always wanting that settlement accounts. How are we going to get that settlement accounts? We're going to use that collateral cash deposit account that is mandated by the statute, by the provisions, by the law, right? That they have to have in their constructive possession before they ever even gave us a loan. The reason I keep stressing this to you guys is because even if you don't pick up anything else tonight, as long as you understand that they actually had to have real cash on the premises at hand in order to give you a loan. They couldn't have done it. They can't do it because the actual cash is overseas because they're just an affiliate or a branch thereof. Would have to at an international banking facility outside of the United States. So in order for them to even give you a loan, to create a mortgage, to engage in real estate, okay, they have to be an international banking facility outside the United States pursuant to, write it down, Title 12, Code of Federal Regulations 204. All right? Both Sections 13 and Sections 14 of the Federal Reserve Act permits the advancement of funds secured by a deposit or pledge of bonds from the borrowing bank and to buy and sell bonds issued under the provision of subsection C of Section 4 of the Homeowners Loan Act of 1933. Now, I understand about these homeowner loan acts and things of that nature because I read the entirety of the 73rd Congress First Session, Volume 77, Part 1. After they cured the whole banking emergency by creating the internal elastic currency, which is notes, drafts, bills of exchange, bank and trade acceptances, okay, which is worth 100 cents on the dollar. It's the new money, as you will, and we have the ability to draft it and draw it into existence, all right? And those notes, drafts, bills of exchange, bank or trade acceptances are at actual face value, and it goes to the comptroller of the currency through the federal discount window, depending on how you endorse it. Comptroller looks at it and then issues the Federal Reserve to issue Federal Reserve notes for your security that is a collateral security and obligation of the United States. Okay? And those Federal Reserve notes shall be worth 100 cents on the dollar, and they're really just securities too. So all we really have going on here is paper for paper, security for security. All right, this is busybody shit. Mortgage-backed securities, aka whole loans, trusts, are restricted to member bank transactions. You can't even have a special purpose vehicle trust. You can't have a whole loan. You can't have mortgage-backed securities because they're restricted to member bank transactions and might be eligible securities. However, the lending bank and the borrowing bank transactions are settled at an international banking facility, which again means, ladies and gentlemen, you couldn't possibly be involved in a mortgage-backed security or loan. It's impossible. There's no way. There's just no way. When in 1983, the comptroller of the currency ruled that a bank had violated permissible real estate loan provisions. Okay, understand the comptroller of the currency has the control to create the rules and regulations, but his rules and regulations still have to fall within the confines of the Federal Reserve Act of 1913 and the public law and the 12 CFR and Title 12 USC. Still has to fall within those parameters, okay? So when in 1983, the comptroller of the currency ruled that a bank had violated permissible real estate loan provisions. How did the comptroller of the currency rule? Is he a judge? You bet your ass he is. He's a ministerial administrator. He's not a judge. He's a ministerial administrator. He's charged with the duty of overseeing how transactions are functioning and making sure they're all within the regulations, rules, and policies, and the law. So the comptroller of the currency ruled that a bank had violated permissible real estate loan provisions as decided in the Supreme Court case National Bank versus Matthews. United States, January 1st, 1878, a loan or extension of credit cannot be secured by real property and the contract is void. That case hasn't been overturned. Ladies and gentlemen, that's case precedent. All right, from 1878, it's not been overturned. A loan or extension of credit cannot be secured by real property. Do you have real estate or do you have real property? Did they do an unlawful conversion on your would-be marketable title? It's really shadow title now because they muddied the waters with what they did, which is theft by taking, unjust enrichment, unlawful conversion, RICO, extortion. Okay? So again, a loan or extension of credit cannot be secured by real property, and the contract is void. What is the loan or extension of credit actually backed by? You guys remember what it is? The collateral cash deposit, bookkeeping entries, which is their liability, which is your account payable, due and owing to you, and you can utilize it to set off or offset the alleged balance due and owing and zero balance the books. First National Bank, Bel Air versus Comptroller of Currency, United States Court of Appeals, 5th Circuit, May 13th, 1983. Source: the purpose of Title 12, United States Code, subsection 29, that's Title 12, United States Code, subsection 29, is to keep the capital of the banks flowing in the daily channels of commerce. All right? In a fictitious monetary system, if it's not ebb and flow, if it stops, even for an hour, it all fades away. It always has to be in motion, just like the blood in your circulatory system, dealing with your heart, your lungs, and everything else. It's always got to be in motion, guys. All right? So Title 12, United States Code, subsection 29, is to keep the capital of the banks flowing in the daily channels of commerce. To deter them banks from embarking in hazardous real estate speculations and to prevent the accumulation of large masses of such property in their hands to be held, as it were, in Mort, Maine. National Bank versus Matthews. Source: National Bank versus Matthews. Again, that was January 1st, 1878. Here's the Justice Miller, and I love this. Justice Miller dissenting. I am of the opinion the National Bank Act makes void every mortgage or other conveyance of land as a security for money loaned by the bank at the time of the transaction to whomsoever the conveyance may be made. That the bank is forbidden to accept such security, and it is void in its hands. 1. The land can't be used as the surety. It's got to be what? The collateral cash deposit account. It's got to be the collateral cash deposit account or the collateral deposit account. It can't be real property. So what do they call it? Real estate. Repurpose it and reclassify it. You have the power to do that. But you also have the power to point out that they can't give a loan or real estate transaction. They can't even allow you to make deposits. Man, I cannot believe what Carl's sharing with all of us. I'm absolutely smitten. Now you guys understand why I can't sleep, because this is just wild. This is crazy. You heard me talk about status correction once? Nope. Heard me talk about putting a butt print, thumb print, mushroom stamp on a piece of paper yet? Nope. It's just simply understanding the law and the policies and procedures to the transaction. No butt stamp, you ain't got to lather up lipstick on your lips and kiss the banker's collar. You don't have to pull your wang between your legs and let her fly and mushroom stamp the paper. Let's see, are we going to get into this one? Yeah, we're going to read this one too. I'm going to omit the names in here because although he's got it publicly on his wall, I'm not sure that these people want their name floating around, and a lot of people are recording what I'm saying. And so, for their benefit and their privacy, I'm going to omit their names. I have a good friend who used to clerk at the United States Supreme Court. One day, he called me and asked me about the cash collateral deposit account. And I said, well, we'll just call him Jay. I didn't come up with that provision, but even the Bank of International Settlement uses that provision. So does the IMF. However, in Europe, the collateral deposit is bank-issued securities. Not so in the Western Hemisphere. It has to be cash, and I've used it successfully several times. It even works with credit cards. Oh, I bet you want me to rewind, don't you? I bet you want me to rewind that a minute. Let's rewind. I have a good friend who used to clerk at the United States Supreme Court, and one day he called me and asked about the cash collateral deposit account. And I said, well, Jay, I didn't come up with that provision, but even the Bank of International Settlement. Why is the Bank of International Settlement so important? Ladies and gentlemen, the Bank of International Settlement is the big swinging dick in the valley. Even the Bank of International Settlement uses that provision, so does the IMF. However, in Europe, the collateral deposit is bank-issued securities. Bank-issued securities, Federal Reserve notes, right? But they don't have that over here. See, because they're just bank branches. They're extensions of the foreign bank in another country, all right? So the branches don't actually have the capital to actually create the collateral deposit account. And the books will reflect that it is just a book entry. Not so in the Western Hemisphere. It has to be cash. And I've used it successfully several times. It even works with credit cards. Why would it work with credit cards? Because again, they're just financial institutions. They're just financial institutions. The same rules apply to them. They're negotiating securities. They're alleging and purporting to give you a loan, and you're giving them an over-the-counter security in the form of an application, which has actual cash value, and they have to match it with a credit liability, and all they're doing is a book entry. And you can use the collateral deposit account and use it to set off and zero balance and render and close the account anytime you please. Anytime you please. But by all means, continue to gratuitously give them your sweat equity Federal Reserve notes that you go bust your hump for. Because that's just gratuity. That's a Class 5 gift in a state. Okay? Or you could learn how to articulate collateral deposit account. You can go in the bank. Hey, Jerry McGuire, work with me here. Collateral deposit account. What do you think when I say that? Just the first thing that comes to your mind. Collateral deposit account. You could go in there and fuck with them. You can go in there and fuck with them just for shits and giggles. I think when I hear those three words, I'm supposed to go call my manager. Oh, well, would you mind doing that? I want to see what he has to say about collateral deposit account so we can negotiate, so we can settle and close this issue. Case in point, a friend called me way back when and said he had a collection case against him filed in court, the Bank of America, or by Bank of America. So I asked him, is there even a chance you still have the original credit card application? He said, well, yes, I do. I save everything. So I said, well, bring it to me. I already knew what I was looking for. On about the second or third page, written very small, written in very small lettering, was this: under the conditional acceptance of this agreement, should the cardholder fail to remit required payment to the card issuer, the issuer reserves the right to apply any or all funds in the collateral deposit towards the outstanding balance owed. Long story short, we asked for the collateral deposit be applied to the presumptive debt. Bank of America agreed, and we withdrew the collection action. Now, back to my friend Jay. He said, well, and remember, Jay is the Supreme Court clerk. He said, well, this lady I'm helping in Florida is actually in foreclosure. I said, just reword the request to a demand for the collateral deposit be applied to the claim, security for security, right? They're just doing an exchange. And he did. On court day, this lady asked the judge to demand the collateral deposit be applied to the presumptive debt. He answered. He didn't have the authority. So we stepped up the game, asked for the continuance of the hearing, and asked the comptroller of the currency to instruct the judge to do it. Okay, this is called procedure. They're following procedure. When you go and you study the Federal Reserve manual and you look at what the Office of the Treasury and all the power and authority they have, remember, guys, this is administrative procedures under the APA. The comptroller of the currency is the one who oversees everything and makes sure that everybody's in compliance. All right? So by taking leave of the court, we need leave of the court. Okay? Something has come to light and we need leave of the court. I don't care if it's for 10 minutes and you're sending an email to the comptroller of the currency, or if you adjourn and take 2 weeks. Your next move is to get a hold of the comptroller of the currency, because the comptroller of the currency is going to call the judge in chambers, ex parte, away from you. You're never going to really see that happen in most instances. And he's going to call up the judge and say, hey, Jim, there's comptroller of currency over here. Oh, yeah, how you doing, Bob? I'm doing real good. How's Nancy? Oh, she's doing all right. Hey, I got this most peculiar letter, and seems like you have a hot ticket item there in your chambers. Yeah, why don't you go ahead and do exactly what they told you to do. Okay, no problem, Bob. Thanks. All right, talk to you soon. Plan on golfing with you Wednesday. Click. The comptroller of the currency has the authority to tell the judge what to do. Why? The judge is administering a bankruptcy. He's an administrator too, but the comptroller of the currency is above him, especially because what's transpiring, the nature of the transaction. To instruct the judge to do it. Within a few days, the OCC, Office of Comptroller of Currency, sent a letter to the judge and informed him to apply the deposit. Forced to, he dismissed the foreclosure case and stormed out of the courtroom pissed. You want to know why that judge is pissed off? Because they just removed his ability to profit from their ignorance by getting the Office of the Comptroller of the Currency involved. And once the Office of the Comptroller of the Currency is involved, if that judge doesn't do exactly what that officer of the Comptroller of the Currency tells him to do, guess what? Title 18, 1005, do not pass go. Do not collect $200, go directly to jail, and pay somebody $1 million on your way. If I may, all of them collectively wanted to implement international banking provisions. We so be it, International contracts, in whatever form, have to have a copy of the collateral deposit for the sole purpose of set-off or offset of claims. So there's got to be the collateral deposit account for the very purpose, for all participants involved, for the purpose of set-off or offset for any claims that may arise. Okay? Or maybe you want to be preemptive and you want to do it shortly after the transaction. You say, hey, use the collateral deposit account for the purposes of set off, so we can avoid any future claims and render and settle and close the account. Perhaps in law, there is no other formidable weapon devised against the American people than federal preemption. Federal preemption. This is where you're going to learn that the state and the state court judges and the lower court judges in the state can't use the state statutes, codes, city ordinances, rules, and regulations, because we have this nifty little thing here called the federal preemption. Congress is coming in saying, hey, none of that can happen at the state level because all of these transactions are federal. Why? Because the United States government is backing all these real estate loans or mortgages with bonds, all right? So they have an interest in it. And the law for these transactions is federal, not state level. But again, you want to make sure you don't waive the issue when it comes up. You're going to make the issue, hey, the state doesn't have jurisdiction over this. You like subject matter jurisdiction, in personam jurisdiction, and territorial jurisdiction. You have nothing. There's nothing you can do with this. And if the judge decides to get a little stupid, what you can do? You get a hold of the Office of the Comptroller of the Currency and politely inform him about Title 18, 1005 and how we got Ipkiss down here, old Pud Pounder beating the bench up again. Two blue pills and he got a heart on 6 miles long. And he's saying, I'm going to go ahead and foreclose anyway, and you can sue me. I'll bet you he don't render a judgment or a decree. I promise you, if you're getting a hold of the Comptroller of the Currency, he's being cocky for nothing. So the federal preemption, this principle, even keeps judges awake at night. Could you imagine why? Because look, think about all those houses they've already foreclosed on, and now you, ladies and gentlemen, are gaining the acquired knowledge necessary to go execute a recoupment. They committed a crime. They robbed you. They robbed you in excess of, what was your property worth? 100,000, 500,000, $1.5 million. Then they engaged in tax evasion, money laundering, extortion, shit. Woo. And remember, there's no statute of limitation on fraud, right? So fraud in the inducement, false conveyance of language, misrepresentation of material facts. Damn. And under Title 18, 1005, it's $1 million, 30 years in prison. That's a good day. The principle even keeps judges awake at night. So let's deal with it and take away their weapons, shall we? Now, for you smart Americans, what we are going to do is take a look at 3 or 4 references dealing with the federal preemption. And if you've been paying attention to me on Facebook today, I got this badass book from the Supreme Court. One of my other mentors sent it over to me, and I posted a shit ton of preemptions on Facebook today. All right, a shit ton of them, and they're brilliant. Federal preemption, real estate loans, and the mandatory cash collateral deposit account. Seatbelts might be required. My comments are in brackets. Here we go. Federal preemption. Federal preemption. This is where they're barring the state from being able to foreclose on you. This is the other federal preemption here is going to be the fact that these alleged banks can't deal internally with American citizens, okay, in the several states. Title 12, write it down, United States Code 371. Title 12, United States Code 371 refers to a federal statute that essentially allows national banks to engage in real estate lending activities, and under the doctrine of federal preemption, this means that state laws which attempt to regulate these activities by national banks are largely superseded by federal law, essentially preventing states from imposing stricter regulations on national banks regarding real estate lending than what is set by federal guidelines. Everyone okay with that? So the Comptroller of the Currency has stated that there is in fact a federal law that permits national banks, NA, to engage in real estate. What's that NA stand for? National Association, National Banks. To engage in real estate lending activities. However, in the same breath, national banks are not permitted to use any state laws, period. They're not allowed to use any state laws at all, guys, to foreclose on you. If you're looking at the pleadings and it is littered with state code and state law and state statute, ladies and gentlemen, you just won yourself a chicken dinner. When you go into that court, you should be walking down there like you're on The Price is Right and going to meet Bob Barker. You should be high-fiving people in the pew. Yeah, I made it. It should be an exciting day. It is an either-or proposition. They are not permitted to use any state law. Fall on your own sword, as it were. Over the years, some have sent me state court cases they are embodied in or embroiled in, and the case lists a state law or code being used. I know instantly the case is worthless, because if the court entertains such petition, it would immediately eviscerate federal preemption, and that's what you call ta-da. They're finished. The goose is cooked, okay? Ta-da is what God allegedly said when he was done after 7 days and 7 nights. He said ta-da, which means it is finished. 2, Title 12, United States Code, write it down, 371. Title 12, United States Code 371. According to Congress, Public Law 89-485, Section 6H. That's Public Law 89-485, Section 6H. H. The application of this act and of Section 23A. Everybody remember what 23A is part of? The Federal Reserve Act of 1913, right? You guys remember that? The application of this act and of Section 23A of the Federal Reserve Act, Title 12, write it down, Title 12, United States Code, subsection 371, as amended, shall not be affected by the fact that a transaction takes place wholly or partially outside the United States, or that a company is organized or operates outside the United States. Now, I'm willing to admit to all, what we have here is the ultimate federal preemption. One could possibly envision Congress, our lawmakers, list Title 12 United States Code 371 as a mere codification of Section 23A of the Federal Reserve Act of 1913, financial transactions with member bank affiliates. What we have here is a juxtaposition. Both provisions are true real estate loans, however, restricted to member bank affiliates, financial transactions secured by a cash collateral deposit, as we shall see. 3, mandatory collateral deposit. H.D. Fitzpatrick Jr., individually and as a director of the Bank Josephine, Postonburg, Kentucky, an insured state non-member bank, petitioner versus Federal Deposit Insurance Corporation, respondent, number 843129, United States Court of Appeals, 6th Circuit. The lending limit for a member bank is an amount equal to the limit on loans to a single borrower established by Section 5200 of the revised statute, Title 12, United States Code 84. That's Title 12, United States Code 84. The lending limit of Section 22, amended by Section 23A in 1933, are implemented by the Federal Reserve Board Regulation O, which reads in relevant part. I believe I got to go to the next one here. Shit, which one was that? Mother of pearl. off a piece of that. I'm going to have to go back there and scroll away. There it is. Neither foreign banks, National Banking Association, EDGE Act corporation agreements, corporations can accept a deposit from an American citizen, i.e. no permitted payment, no enforceable contract, sources Title 12, CFR 211-601, status of certain officers for purposes of the International Banking Act, restriction on interstate banking operations. So neither foreign banks, national bank associations, EDGE Act corporations, agreement corporations can accept a deposit from an American citizen, i.e. no permitted payment, no enforceable contract. The source is Title 12, Code of Federal Regulations, CFR, subsection 211.106, status of certain offices for purposes of the International Banking Act, restrictions on interstate banking operations. Let's go back here. Crash course on how to understand international finance provisions and not read oneself into it, because all of these criminals will steal all of your real wealth with just dried ink on paper. I gotta expand the screen. I'm going blind. Hold on a second, guys. Where to go? Crash course on how to understand international finance provisions and not read oneself into it, because all of these criminals will steal all of your wealth with just dried ink on paper. A brief synopsis. Credit may be extended by a financial institution to a consumer. And this is, again, I was reading this and I knew Title 15. I screwed up. Credit may be extended by a financial institution to a consumer. A financial institution's premises permissive operation are limited to Title 12 United States Code 1843. That's Title 12 United States Code 1843. Banking business outside the United States. So credit may be extended by a financial institution to a consumer. A financial institution's permissive operations are limited to Title 12 United States Code 1843, which states in part, banking business outside the United States. Ladies and gentlemen, were you outside the United States when you got a loan? I bet you weren't. I bet you were internal. I bet you were domestic. I bet you were in one of the several states. A consumer has to maintain a transaction account. Okay? So the consumer credit transaction has a transaction account and makes it all commercial and makes you liable. A consumer has to maintain a transaction account as defined in section 461B of Title 12. That's 461B of Title 12. Restricted to an international banking facility outside the United States. Did they just put you outside the United States if you're running around telling them you're a consumer? Yes, they did. Are they going to hang you out to dry on Title 15, 1601 through 1693? Yes, they are. Will they let some of you get through so you can run around and flaunt your shit and tell everybody on social media, look, I did it, you can do it. Everybody come my seminar, lazy American, you can do it. Yes, because they'll let a few of you guys through because you'll all be so proud of yourselves, like I was, and make an egregious mistake and bring your family and your friends into their venue, and they will fleece your family and friends. They will rob them fucking blind, all because you were under the illusion and the fallacy that you had done your homework correctly. I want to pause at this moment in time. I can't thank Carl Collicott enough. Thank you, Carl Collicott. My prayers will forever be with you. Thank you for putting out that information. And also Phoebe. Had it not been for Phoebe getting a hold of me and saying, hey, I got some things you should probably look at. Bless her heart. What a goddess. What just awesome people. The good Lord just brings awesome people at the right time, at the right place to you. You just have to be receptive, right? I very, very, very rarely ever open an email or a Facebook message or any of that shit. And by the grace of the Heavenly Father, Phoebe gets a hold of me and I see it pop up and I'm like, why not? Something's telling me to open it, and I opened it, and that's how I ended up coming into this information, was from Phoebe. So we owe her a great bit of gratitude as well. The Gramm-Lee-Bailey Act, which is essentially how Title 15, 1601 through 1693 got created, right? Did not repeal the Glass-Steagall Act. This threw me for a loop. I knew about the Glass-Steagall Act. I was certain that it was repealed. The Gramm-Lee-Bailey Act, I was certain that the Glass-Steagall Act was no longer in place. And in gleaning this information here, I'm excited to do some new research on it. Did not repeal the Glass-Steagall Act, forbidding investment firm from commercial banking. It merely provided permissible commercial banking outside the United States for foreign government-issued bonds. Remember how earlier you guys were trying to figure out why I was all amped up? And I was trying to convey to you guys that the Congress is behind it. The Congress is behind it because they're issuing these bonds. They're getting a kickback out of the deal. They're more than happy to allow you to run around and engage in confession and judgment. And their low rent, Article 1, Section 8, military tribunals that are administering a bankruptcy and fleece you guys to cover the bonds they're issuing for the whole RICO racketeering scheme they got going on. All right? So the Glass-Steagall Act forbidding investment firm from commercial banking, it merely provided permissible commercial banking outside of the United States for foreign loans, foreign real estate mortgage transactions, all foreign outside the United States, and must be backed by collateral deposit accounts, not book entry. Government issued bonds. The Comptroller of the Currency cited authority for real estate loans, Title 12, United States Code 371. Title 12, United States Code 371 is the Comptroller of the Currency citing this for real estate loans, Title 12, United States Code 371, is merely a codification of Section 23 of the Federal Reserve Act. Transactions with member banks secured by a cash collateral deposit of 100% cash of the face value of the transaction, which means you're over-the-counter security. It's face value. Loan servicers, National Star, Mr. Cooper, SPS, Shellpoint, ETL. Aside from the fact there are no permissible real estate loans in regards to any American citizen. Let me repeat that again, because you might want to get the Q-tips out, get the ear candles out. I don't think I understood what this guy's saying. Loan servicers, National Star, Mr. Cooper, SPS. You know, he got that sunscreen on, old SPF over here. Shellpoint, ETL. Aside from the fact there are no permissible real estate loans, in regards to any American citizen, are not permitted to conduct business in the United States. Title 12, United States Code 1843, nor accept a deposit from an American citizen, since a payment in the form of a deposit would validate such a lawless claim and implicate Congress as accessories before and after the fact of facilitating the theft of real property. Damn. That's a wrap. That's so powerful. Now you guys know why I haven't been asleep. I haven't been able to sleep since I got my hands on this stuff. I haven't been able to go to bed. So simple, so eloquent, so sweet, so to the point. No arguing, no controversy, no nada. Put it on a piece of paper, mushroom stamp it if you must. Put your butt print on it, I don't care. But make sure it gets delivered. to the proper individuals in the right capacity to handle it, the comptroller of the currency. The actor, Robert Young, who played the role of Marcus Webley, MD, refused to go out in public because he grew tired of the people asking him about their health issues. As he stated, the average American cannot discern reality from fiction. Source, Public Law 90, Public Law 90321, Public Law 90321, subsection 100, short title. This title may be cited as the Truth in Lending Act. This is where he just blew my doors off. This is finally where I set my ego aside and was like, I can't beat him, join him. We got to correct this now, because when he blew open this section for me and started talking about Regulation X, Regulation Z, I'm very familiar with all that stuff. And it blew the doors wide open. This title may be cited as the Truth in Lending Act. Subsection 102, Finding and Declaration of Purpose. The Congress finds that economic stabilization would be enhanced and the competition among the various financial institutions and other firms engaged in the extensions of consumer credit would be strengthened by the informed use of credit. And that's when I finally understood it. Title 15, United States Code 1681A, definitions, rules of construction. T, financial institution. The term financial institution means a state or national bank, a state or federal savings and loan association, a mutual savings bank, a state or federal credit union, or any other person that directly or indirectly holds a transaction account as defined in sections 461B of Title II belonging to a consumer. Title 12, CFR 204.8. Title 12, CFR 204.8, International Banking Facility. This part is issued under the authority of Section 19, Title 12, United States Code 461. Under Section 19, Title 12, United States Code 461, International Banking Facility Time Deposits and International Banking Facilities. Public Law 106 through 102, 106 Congress, 106th Congress. Section 509 definition. A, in general, the term financial institution means any institution the business of which is engaging in financial activities as described in sections 4K of the Bank Holding Company Act of 1956. Public Law 89-485, July 1st, 1966, an act to amend the Banking Holding Company Act of 1956. Section 6H, that's Section 6, number 6, H is in Harry. The application of this act and of Section 23A of the Federal Reserve Act, Title 12, United States Code 371, Title 12, United States Code 371, as amended, shall not be affected by the fact that a transaction takes place wholly or partially outside of the United States, or that the company is organized or operates outside the United States, provided, however, that the prohibition of Section 4 of this Act shall not apply to shares of any company organized under the laws of a foreign country that does not do any business within the United States, if such shares are held or acquired by a bank holding company that is principally engaged in the banking business outside the United States. Title 12, United States Code 1843. Again, it's all got to be done outside the United States. When did they put you on a boat, a plane, a train, and get you out of the United States? They take you on holiday to France or Rome or something so you can sign a good deal and get you a loan. They didn't. Title 12, United States Code, subsection 1861. Title 12, United States Code, subsection 1861, short title and definition. A, short title. This chapter may be cited as the Bank Service Company Act. Title 12, United States Code, 1861, Bank Service Company Act. 2, the term bank service company means A, any corporation, number 1, which is organized to perform services authorized by this chapter, and 2, all of the capital stock of which is owned by one or more insured depository institution, and B, any limited liability company, and 1, which is organized to perform services authorized by this chapter. 12 United States Code 1864, permissible bank service company activities for other persons. F, geographic location. A bank service company may perform at any geographic location any service other than deposit taking that the board has determined by regulation to be permissible for a bank holding company under sections 1843 C8 of this title. I need to wet my whistle here and take a break. Let's bring some people on the panel. 200 and some people. Thanks for joining us again, ladies and gentlemen. We are very fortunate, Carl and Phoebe, for putting us on notice, sharing this tremendous information. I'm telling you right now, I hang around a lot of intelligent people, and I'm going to tell you right now, as soon as I laid eyes on it, I saw its value, and it's so much more than what's being expressed here. I don't think people really comprehend what he's sharing with everybody. This is so much more than a new house, a new car. We're talking roads, bridges, dams, infrastructure, the ability that you have to draft and draw into existence what is needed, and sit down in the park with a group of people and say, hey, let's figure out how we can help, what we can do. Let's get our funds back from these banksters that are taking it over there to England or Europe or Germany, or let's take back what's rightfully ours. And we can do it in a positive way that requires no violence, and we can play kick-ass music while we do it, right? Anybody want to come up here? I see a couple people. And again, the only reason I'm doing this tonight, and I'm not fluent in it yet, by the time I'm fluent in this, I'll be able to rattle this off like I was rattling off Title 15, and I can breeze through that stuff with my eyes closed. And I'll be able to do the same with this. And I would encourage all you guys that are going to implement this to do the same. There's no substitution for reading, guys. And so share this with your friends and your family, brothers, sister, cousin, uncles, and aunts. Sit down. Each one teach one. The more that you talk about it, the more that you practice, the more that you interact, the more and the easier it will be for you to commit it to memory. I mean, this is an infinite source of funds right here. All you have to do is learn how it functions and hold them accountable by putting them on notice. It's a done deal. How's it going?
Good, man. How you doing?
Any questions?
Yes. What would be like the first step to implement this?
I can't hear you, brother. You must be muted. Hold on a second. Oh, there you go. You're not muted. I got you. Go ahead.
What would be like the first step to implement this? Because as of right now, my house is going into foreclosure. I live in California.
Right. So again, go to Carl Coleycott's wall on Facebook, or you can go to my wall on Facebook, or you can go down into my TikTok. But I would rather you go directly to the source. Okay.
So because your Facebook or Carl's?
Go to Carl's, and this is why we always go to the source.
Okay.
And here's why. Because what I had to do, I don't have social media on my computers. I was informed not to do that, so I never have done that. So everything I was copying and pasting and putting into, you guys would have laughed. If you'd have saw the painstaking operation it took to copy all of that on this phone and then transfer it over into my email, and then I would exit out of the Facebook and jump back into my email and paste it in the email and jump out of the email, and then I'd have to scroll for 20 fucking minutes to get all the way back down to the fucking bottom. And I did that for hours to get all this. I have 37 emails to myself, and they're all long as shit. And I literally went and copied everything just in case tomorrow Facebook collapsed, because I realized the value, what he has actually given everybody, is astonishing.
What's his name on there?
Carl Collicott. I believe I'm pronouncing that right. And if I'm not, my apologies. CarlCollicott. And again, this is just the beginning of it.
Which one is it?
It doesn't have an image. It's just gray.
It's the one that says one follower, gray?
I don't know.
From Huntington Beach?
Sounds correct.
Okay, cool.
You'll know as soon as you open it up. And look, take your time and scroll through there. A lot of brilliant people in there too. I know a few of them. I've talked to a few of them. Phoebe being one, and another as well. And we've been sharing information because I'm just floored. I'm flabbergasted, first of all, that it's out in the public like that and just freely given, and people are just passing by it.
Yeah, I stopped what I was doing.
They're tripping over a bar of gold to pick up a pissant, and I'm like, what are you guys doing? Go read this shit. Go read it. I can't believe it's out there like that, because I've never seen it out there like that. Not stuff like this. There are a lot of processes and stuff that people have given to me. It's just not freely out there on the internet like that. And if you just take the time to slow down and really read it, his narration is brilliant. He really breaks it down. He understands it very well. And he removes all the mundane confusion that would normally be intertwined with all the pronouns in the code. And he really fundamentally breaks it down. I mean, as I was reading, I was like, this is the Holy Grail. This is awesome. Now, I'm not saying it's the end-all be-all by any means, but this is something that will definitely help you out. Because, again, are they trying to foreclose on you in state court?
I think it's federal. I'm not sure. It might be state. It's the bank I got the loan with.
Right. Well, you haven't been obviously served yet.
No.
Okay. I would venture to say, because I've never, at least in my experience, I've never seen it in a federal court. They always do it in district courts. Okay. They always, and then there's states that are non-judicial foreclosure states, and they're a real cocksucker. My point to all this is, I would find it hard to believe that they would be trying to foreclose on you in a federal, but they might. So I'm not going to discount it and discredit it. But the second they bring it into state court, you got them.
Okay.
You absolutely have them. And in order to understand what I'm talking about, you're going to have to go read his wall.
Yeah, no, for sure. For sure. I will. I got him now. Yeah, he's got all kinds of good stuff on here.
Yeah, I don't want to send it to you because if I didn't copy something properly, I mean, that's why I'm on here tonight. My heart was hurting because I thought of all those people that I have been teaching throughout the years, the FDCPA, and my heart was just hurting knowing that they're all in danger. And there's a better way.